Hello, good afternoon, and welcome to this webinar called Making Wills for Blended Families. My name is Kerry Parsons, and this is my colleague Alex Strickland, and we both work in the Private Wealth and Inheritance team. I'm a senior solicitor, and Alex is a solicitor within the team. Before we start the main part of the webinar, just wanted to mention a couple of things about Harrington Carmichael. We are a full service law firm based predominantly in Farnborough. We also have offices in Ascot and in Reading, where we're able to see clients if that's more convenient for them. We deal with lots of different areas of law to include corporate and commercial, dispute resolution, employment, immigration, residential property, new build, real estate, family and divorce, and then of course private wealth and inheritance. The private wealth and inheritance team itself, there's 28 of us in the team at the moment, and we cover everything from wills to powers of attorney, estate administration, trusts, and court protection work. Alex is now going to talk about what a will is.
Hello everyone. So yes, what is a will? So a will is potentially the most important document you'll ever make in your personal lives. It's a document that sets out your wishes for how you wish for your estate to pass after your death. You can create, if you're on your own, or even if you're on a couple you wish to do so, create a will as a single will, or you can make a conventional mirror will where you would leave everything to each other and then onwards after the second death, or alternatively a mutual will, which is in essence a contract between the two of you that you will never change your will, and it can be deemed to sort of add a layer of protection to stop your spouse from sort of cutting people out of your will, but it doesn't offer very much flexibility and is therefore not recommended. But what happens if you don't make a will? As I just said, it's one of the most important documents you'll ever make. And the reason for doing so is because if you don't make it, then the law will decide who inherits on your death. And that's called the rules of intestacy. Now, what that generally means is that your spouse, if you are married, will receive the first £322,000 in your estate. And if you have any children, then your spouse will receive a further 50% and your children will receive the remaining 50%. If, for instance, you haven't got any children or you're not married, then the law also decides what happens in those circumstances. So it may go to siblings, it may go to parents, and it can just get a bit complicated. And it may mean that the people that you intended to benefit, sorry, you didn't intend to benefit, will end up benefiting. Also, crucially, if you are unmarried and living with somebody, then the intestacy rules do not provide for those people. It only applies if you are married. So you could be living with a long-term partner and be what you consider common law married, but they will still not be entitled to anything under your estate when you die. Additionally, if you didn't do a will and your spouse did benefit from the first $322,000, this may not be the most tax efficient method, because generally anything you leave to a spouse is completely exempt from inheritance tax. And if not everything is going to go to your spouse and you've got a larger estate, then you may end up having to pay some inheritance tax on the first death, which is not desirable.
So what do we mean by a blended family? So typically when we're talking about blended families, we're talking about a couple that have got together. They may be married, they may not be, who potentially have, perhaps they've got children from a previous relationship, or it could be a couple that have got together. One's got a child from a previous relationship, and they may well have children together as well. So that they're kind of the normal kind of situations or sort of circumstances where we would call it a blended family. So what are your options with regards to your will? Well, we've set out here 3 options. There are other things that can be done in wills, but these are kind of the 3 kind of standard wills. So we've got a basic standard will, is the first option. So Alex will talk to you about that in a moment. We've got a life interest trust will, sometimes called an immediate post-death interest trust. And then we've also got a discretionary trust will. And we're going to talk about each of these in turn now.
So, so a basic, simple wills. As I mentioned earlier on, you've got the simple will and you've got the mirrored wills. These are the conventional approaches. When you've got a simple will and a single will, it can just be sort of left to anyone. It could be to your children if you're not married. And if you are married, typically you would both mirror your will so that they say the same thing, just with the names inversed. This is deemed to be a very tax efficient way of doing things because, as I said earlier on, anything you leave to a spouse is completely exempt from inheritance tax. And so your nil rate allowance that you have towards inheritance tax can be also transferred over to the surviving spouse on the second death, which would just mean there's no inheritance tax to pay on the first death, which is nice because it alleviates some of that stress. If you're in blended families, there's no guarantee, though, that the surviving spouse or partner won't disinherit any children that you brought into the family. It may not be malicious. It could just be in the sense of they've got remarried if you died quite young, and then they've died before their future wife or husband, and then they've decided that they weren't going to benefit your children. But it can just be one of those unintentional disinheritances. Otherwise, it can be malicious, and it just needs to have a lot of trust required for these kind of wills to work in these kind of family scenarios. And it's not to say that they can't work, and they can be a suitable option in many circumstances. But where you do want to have a little bit more control over what happens to your half of the estate, if we may call it that, you have a life interest trust, or as Kerry mentioned, a immediate post-death interest in possession. What this does is it enables you typically to ring fence perhaps 50% of your estate, be that property or some cash that you have, and it will go into the trust. And what that means is that your surviving spouse or partner will have a right to the income that that trust produces, and or a right to reside in the property for the remainder of their life before passing to your ultimate beneficiaries, which would typically be your children, and your spouse would have the same thing mirrored in their will to protect their side of things as well. It's important to note, though, that if you're unmarried, it might not be the most tax effective for a partner, because if it's left in the trust, you may not benefit from what's called the residence nil rate band, because that has to pass to a lineal descendant in order for you to qualify for that. And if you're unmarried, then your stepchildren, if they wouldn't technically be, would not benefit. You wouldn't be able to benefit from that relief. The other thing to note as well is that you don't have to do things equally. If you've come into a relationship with unequal amounts of money, and you bought a house together and you're both putting in unequal shares, you can do a declaration of trust as well, which can sort of dictate what would happen and what shares specifically would go into that trust. So it could be a 60-40 split. And that's something you can talk to your solicitor about as well, if that's an option for you.
And so the third option we're going to cover is a discretionary trust will. These are typically the most flexible types of wills that you can make. And effectively, what happens on your death is your assets go into almost like a pot. So that's like the trust fund. And then you pick trustees who would manage that trust fund, and they would decide how those assets are distributed. What you would do in your will is you would appoint what we call discretionary beneficiaries. So you would list out, for example, a partner, a spouse, children, stepchildren, grandchildren, siblings, whoever you want. And it would be the trustees who would decide which of those beneficiaries get what from that trust fund. They would typically be guided by a letter of wishes, which would be prepared at the same time as your will. And that letter of wishes would set out what your thoughts are. It wouldn't be binding on the trustees, but it would set out clearly what your intention was when you made the will, and perhaps why you've made the will in the way that you have, because that is also often important when the trustees are making decisions. The good thing about this particular type of will is that the letter of wishes that sits with the will can be updated as regularly as you like. So as and when your situation or circumstances change, you can update that letter of wishes. So for example, if you're in a relationship, you're not married, so you decide not to go down the life interest trust route because it's not tax effective. If you were then to later get married, you might want to put into, you would need to firstly re-sign the will because marriage revokes the will, but you might want to put into the letter of wishes, if you still want a discretionary trust, you know, that they should consider appointing out the property, for example, on life interest trusts, because the trustees would have the flexibility to do that. They can appoint out on other trusts typically, or they can appoint out absolutely to your beneficiaries. So it's really, really flexible. It is really great. If your circumstances perhaps may change quite a lot over the coming years, I think, you know, it's definitely a good will to have in place if you are an unmarried couple, just so you can look at the situation as at the date of death, and perhaps the trustees can decide to distribute your estate in accordance with your wishes, but in the most tax effective way, if that's something that's important to you. I appreciate with some clients, tax is not always that important to them, but if it is, then that can obviously be looked at. One thing to note with trusts, yes, there can be more administration to them. You do have to register them now with HMRC, and particularly with discretionary trusts, you know, there are 10 yearly anniversary charges, so you have to kind of file with HMRC every 10 years, and also there can be exit charges when money goes out the trust. But quite often these things can be avoided with regards to the anniversary charge and the exit charge if assets are pointed out in the first 10 years. Also, it's just another point to note is that if you do go down the route of a discretionary trust, you may lose the residence nil rate ban that Alex briefly mentioned, because in order for the residence nil rate band, which is currently £175,000, to apply, property has to pass out to direct descendants. And if it's in a trust where no beneficiary is absolutely entitled, then you wouldn't qualify. That said, you can appoint assets out within the first 2 years, and by doing that, you may be able to apply the residence nil rate band. So it's really flexible, and it's a really good will for many of our clients. So how do you go about making a will? Quite often we get asked the question, you know, why don't I just go to a local will writer, or, you know, they're only charging, you know, a small amount to draft a will, or, you know, why don't I just go down to the local shop and get a will pack? We see time and time again people that do this, and these wills are often fraught with issues. You know, they don't set out exactly what they want to happen, or they're not executed correctly. There's all sorts of issues. What we would advise you do is you sit down and you look at your assets and your circumstances, and that you actually meet with a solicitor to discuss your circumstances and the options. It's particularly important where you are a blended family. If you're trying to kind of protect the interests of a partner, spouse, as well as your own children, it's really important that you get it right, because if you don't, you run the risk that there will be issues when you pass away, with claims being made on the estate, for example. Here, what we would normally do is we'd arrange an initial meeting where we would run through absolutely everything with you. We'd give you any inheritance tax advice you require. And then once we've got a plan as to what will would be best for you as a client, we would then go away, draft the will for you. You would approve it, and then it would all be finalised. But it, you know, I think the point I'm trying to make here is it's really important to get good advice and to make sure that your will is right for your circumstances and that it does give effect to your wishes. Yeah, we fully advise you to seek legal advice. That's mainly all we want to talk about today. Of course, if you do want any further information on making a will, if you are a blended family, or if you just want to make a will, or you need any other advice, then please do get in touch with us, and our details are on the screen here.